Ms. Mascott, it's a pleasure to have you here. We're grateful to have you here. On this last point, I do think it's important to remember the separation of powers matters. We're talking here about a coordinate branch of government. The highest court in the land, the Supreme Court of the United States, unlike the lower courts, is not a creation of the Congress. Now, we determine its size, but we can't relegate that into non-existence as we theoretically could do with any of the inferior courts. And so when we're talking about the apex of a coordinate branch of government, the question is not whether to have those standards in place. The question is who sets them and who does not. And that is not a question of whether you want rules to apply. They do have rules, but they are rules that they themselves have adopted consistent with existing federal law. Ms. Mascott, you've been nominated to the U.S. Court of Appeals for the Third Circuit, a court that's near and dear to my heart, as I served as a law clerk back during the William Howard Taft administration in that, and enjoyed that immensely. So you approached this role. Tell me how you would go about interpreting text, statutory or constitutional, as that's arguably the single most distinguishing feature of the judicial role, particularly the judicial appellate role.
Yes, Senator. So in looking at statutory and constitutional text, I would be looking for the plain meaning or the public understanding of the text that is before the court in that particular case. And as this body knows, that often it always includes starting with the text itself. Not just the text of the word in isolation, but understanding whether the phrase is a legal term of art, looking to the surrounding provisions, looking to how the word is used in other legislation enacted at the same time. But another important point is the timing of the meaning of the phrase would, of course, be relevant based on the time the document became law. So for a statute at the time it was enacted, and for the Constitution at the time it was ratified by state conventions. And if there's still, question to get background, other times people will use the evidence of outside sources to understand what the common understanding or plain understanding of a text would have been. So in my work, the Stanford Law Review article is probably the most emblematic of my deep look at a constitutional phrase. I also looked at dictionaries at the time of ratification and used actually a technique that was coming into use at the time called corpus linguistics, put forward by Brigham Young University with its databases to look at thousands of uses in ordinary or legal language about how a word is used to further understand its meaning. And the importance is to know exactly what definition of meaning was given legal impact by the folks voting on the text at the time, which is why one wants to understand not only how the decision makers themselves, but the public more broadly understood it, because it's not about the individual mind of the legislature, but the objective meaning of the text in the document.
Fantastic. I can't wait to tell my brother about your plug for corpus linguistics, especially out of BYU. And I think that's important when we talk about that approach, looking at the original public meaning at the time of passage, if a statute, or at the time of ratification, if it's the Constitution or a subsequent amendment thereto, is important, and that does matter. In fact, it's exactly what matters. Now, insofar as the meaning of the text is plain and clear on its face, it's going to be an easier task. Where there are ambiguities, that's where lawyers earn their fee, and that's where judges do their best and hardest work. Of those things where it's not plain, what are some of the things that you would look to resolve ambiguities? And in particular, to what extent is it helpful to gain insight into statements perhaps reflecting a particular subjective viewpoint of a particular lawmaker on something? And by that I mean floor statements, statements made in debate, and so forth.
So, Senator, if there was a text where the meaning wasn't originally clear, and as an attorney in the Office of Legal Counsel at the Department of Justice, this was the kind of question we often received. In my experience, it should take a lot to reach the conclusion that text is truly ambiguous, that a lot of hard work should be done looking at that phrase and surrounding phrases in advance, and as I mentioned before, dictionaries and other sources. You mentioned the particular statements of lawmakers, so what we sometimes call legislative history. So if it is a collection of statements it's looked at as one piece of evidence, perhaps okay, but there would never be an instance where the intent of one individual person would have legal impact on the meaning of a text, because the Constitution in Article 1, Section 7 made this whole body, through bicameralism and presentment, and the president responsible for enacting text institutionally and not just one by one.
So in other words, even if you could take one of those statements, and even insofar as one of those statements evidenced a subjective intent on the part of that lawmaker, that isn't relevant, regardless of whether they subjectively believe that, unless that was somehow consistent with the original public understanding of it. That really has no bearing.
Correct, Senator, yes.
Okay. Thank you. I see my time's expired. Thanks, Mr. Chairman.
Thank you. Professor, are you a member of the Delaware Bar?
Senator, I am a member